We will take the officer elections in the order of chair, vice chair, and secretary. The floor is now open for nominations for chair.
Mr. Chairman, I would like to make the nomination of Paul Croce, you, for chairman.
Second.
Any other nominations for chair? Motion's made and seconded to nominate Paul Croce for chair. Any discussion? All those in favor say aye.
Aye.
Opposed, nay. One abstention. The floor is now open for the position of vice chair.
Mr. Chairman, I would like to make the nomination of Bill Nash for vice chair.
Second.
Motion's made and seconded. Any other nominations for chair, vice chair, excuse me? Motion's made and seconded. All those in favor say aye.
Aye.
Opposed, nay.
Abstain.
601. Floor is now open for nominations for secretary.
Mr. Chair, I would like to nominate Michael Fenton for secretary.
Second.
Motion's made and seconded. Other nominations for secretary? All those in favor say aye.
Aye.
Opposed, nay. Congratulations to everyone, and thank you to my fellow members. Next item on the agenda is the approval of minutes. First set of minutes is from the February 5th regular meeting. Are there any, may I have a motion to accept these minutes,
So
approve these
moved.
minutes?
Second.
Are there any motions made and seconded to approve the February 5th minutes? Any discussion, comments, edits? All those in favor say aye.
Aye.
Opposed, nay. Those minutes are approved. May I have a motion to approve the minutes from the special meeting of
January 29th.
January 29th? Thank you.
Second.
Motion's made and seconded to approve the minutes of January 29th. Any discussion? Any edits? All those in favor say aye.
Aye.
Opposed, nay. Those minutes are approved. May I have a motion to approve the minutes from the special meeting on February 5th?
So moved.
Second.
Motion's made and seconded. Any discussion? Any edits? All those in favor say aye.
Aye.
Opposed, nay. Those minutes are approved. May I have a motion to approve the minutes of the special meeting of February 26th?
So moved. Second.
Motion's made and seconded to approve the minutes of the special meeting on February 26th. Any discussion?
Yes.
Yes, Art?
Paragraph 2D. Mr. Weber spoke in favor of the redevelopment, noting that redevelopment could ease the tax. It says stain. We could either put pain or strain there, so that needs to be corrected.
Let's make that strain. So will the maker of the motion modify the motion to approve the minutes as amended?
So moved.
Second.
Are there any other comments on these minutes? All those in favor say aye.
Aye.
Opposed, nay. Those minutes are approved as amended. The next item is correspondence. May I have a motion to receive the memo from James Gedney of the Conservation Commission to Ron Wolanski dated 3/10/2020, referring to the Campos application for master plan approval.
Motion to receive?
Second.
Motion's made and seconded. Is there any discussion? All those in favor say aye.
Aye.
Opposed, nay. The correspondence is received. Next item on the agenda are continuances.
Is this not one?
Yeah, but I'm not going to say that. First item, I believe, is item 5A, application of Jack Gulleson for development plan review, including requests for waivers from certain design standards of the Middletown Rules and Regulations regarding the subdivision and development of land, Section 521, for construction of a new commercial building to include an 18-room hotel with a restaurant and associated site work located on property identified as 59 Aquidneck Avenue, Assessor's Plat 115 SE Lot 169. Mr. Lynch.
Good evening, Mr. Chairman, members of the board. Jay Lynch on behalf of the applicant. We're going to request another continuance for another month. As a result of modifications that we've made to the design, the project had to go back to Department of Transportation for a review of the physical alteration permit. We haven't gotten a response back yet from DOT on the revised plan, so if we'd
So
continue
you're
another month.
requesting continuance to the April 8th meeting?
Yes, please.
This has been going on for some time, and I understand the challenges you have. Are you confident that you will be able to come back ready to rock and roll here next month with this, or is it just going to continue? My
I don't-
suggestion is if it's going to just be continued, we can put it in a controlled fashion and then bring it back to the agenda. It's just an administrative.
If we want to continue it, I'm not sure if DOT is going to have a review back next month. I don't have any indication that it will. So if we want to put it out to the May meeting, perhaps, it's not going to clog up the agenda.
Why don't we continue it to the May meeting? What's the date of the May meeting? You have it there, Bill? Second Wednesday?
The second Wednesday in May is May 13th. May 13th.
So it's your request to be modified to continue this to the May 13th meeting?
Yes, please.
May I have a motion to continue this item to the May 13th meeting?
Motion made?
Second.
Motion is made and seconded. Is there any discussion? All those in favor say aye.
Aye.
Opposed, nay. This item is continued to the May 13th meeting. The second item for continuance,
No.
No.
The matter's been continued
Matter's
to
been
the May
continued.
meeting, so the hearing's not open up.
the next item for continuance is item 5D. Request of James Paradise, owner of property at 170 Aquidneck Avenue, Plat 115 SE, lots 145, 146, 147, for waiver of development plan review pursuant to Section 908 of the Middletown Rules and Regulations regarding the subdivision and development of land. We received a memo requesting that this item be continued to the April 8th meeting,
Actually, to the May 13 meeting.
to the
Mr.
May
Chair.
13th meeting.
Yeah.
Thank you. Sorry about that.
No worries. I'll make that motion.
Okay. So a motion is made. Do I have a second?
Second?
Motion's made and seconded to continue this item, item 5D, to the May 13th regular meeting. Is there any discussion? All those in favor say aye.
Aye.
Opposed, nay. This item is continued to the May 13th meeting. Next item on the agenda is item 5B, application of Mark Haran for preliminary plan and final plan approval of a 3-lot subdivision of land fronting on Lewis Drive and Bailey Avenue, tax assessors plat 125, lot 950. Mr.
Chairman,
Lynch.
just for the record, I'm going to recuse myself from advising the board on this. Ms. Desipel is going to advise you.
Welcome.
Good evening, Mr. Chairman, members of the board. Jay Lynch on behalf of the applicant. We were in front of you at your last meeting, and a couple issues arose. One was on the issue of whether or not a portion of Bailey Avenue that abuts lot number 3 on the proposed subdivision is a public or a private road. The second issue, as a result of some comments that Mr. Nash had, was whether or not we should extend the sewer line and keep it within the right-of-way to lot number 3, rather than having an easement, a utility easement, across lot number 2. We modified our plan to remove the utility easement for sewer and water across a corner of lot number 2, and we went back in front of the TRC earlier this month. At that meeting, the TRC had indicated that they were in favor of the initial plan that we submitted to you, that had the utility easement across the corner of lot number 2 to service lot number 3, that the TRC was not in favor of extending the sewer or water line any further down Bailey Avenue. So as a result of that, we're going to be presenting to you for preliminary and final approval the initial plan that we submitted that had the easement for the utilities across lot number 2. Also, in regard to the issue of the status of Bailey Avenue, I did submit evidence to the solicitor that supported our position that all of Bailey Avenue that fronts this subject property is a public right-of-way. I do know that Mr. Martland had provided evidence to the contrary. We've had discussions with the solicitor, and I think everybody is of the opinion that it's not up to the board, for this board, to make that determination for whether it's a public or a private right-of-way. That venue is the Superior Court to make a determination on that type of an issue. So we're before you this evening on a plan that was deemed complete by the planner. We intend to move ahead with that application. We're going to ask the board this evening for preliminary and final plan approval on that. I do have some additional witnesses here as well who can address some of the drainage issues that we had last time Mr. McHugh was here. So I'm going to have him testify before the board, because I know there were some questions that the board had last time about the wetlands on the site. So I'm not sure how the board wants to handle the issue of the status, the legal status of Bailey Avenue, but I think the solicitor can concur that it's really not this board's jurisdiction to do that.
Before you go any further, let me ask you, is the plan you're submitting the one dated January 28th? That's the one that I have that shows the easement over
Yes,
Lot 2.
that is the plan, January 28th plan.
And with regard to this question on the boundaries, I have to ask the solicitor, should the planning board proceed and let that resolve itself later, or?
There is no clear-cut answer on this. I do agree with Attorney Lynch that the planning board does not have the authority to render a decision on whether this section of Bailey Avenue is a public or a private right-of-way. I would tell you, though, that one of the required findings you have to make tonight in considering the application materials is in Mr. Wolanski's memo to you on page 2, item number 5, which talks about the requirement of lot frontage. And I believe it's the attorney's objectives tonight to talk about Bailey Avenue being public or private and whether that meets the requirements of lot frontage. You are in a tough position tonight because, like I said, you don't have the jurisdiction to make a factual finding about whether Bailey Avenue is private or public. That's something only the Superior Court has the authority to do, but you do have to make a decision on this item number 5 that I just mentioned. So I would recommend that you at least hear the arguments and the attorneys on that issue to start, and then figure out how you want to handle that issue as the first issue tonight.
Well, but if we have to come up with the finding for number 5 that the lot has adequate frontage, and that cannot be determined tonight, why should we take the time to argue it tonight?
My recommendation supports what you have to say. I think until the Superior Court rules on it, we're really not in a position to give you a final opinion. I mean, that finding weighs heavily on this application. So I would suggest that the planning board continue this until we get a resolution from Superior Court.
I can't agree to a continuance. The application has been deemed complete by Mr. Wolanski, so he was satisfied that we met all the criteria to proceed for a minor subdivision.
But we
met all the
cannot
criteria.
determine whether the lot has adequate frontage.
I understand. I understand that this board can't, the objectors, they have the ability to go to Superior Court and get a restraining order to stop you from considering this application. They haven't decided to do so yet. But in the meantime, you've got an application in front of you that's been deemed complete by
So-
the planner.
Question.
And we're prepared to move ahead on that.
So in the eyes of the applicant, in the eyes of the town, it is a public right-of-way as we go forward. Until we see, no, he said he submitted evidence to suggest that it's a public right-of-way. So
Attorney-
that, so then, just let me finish. So that tells me that we didn't have any evidence to suggest that it is not a public right-of-way. So in our eyes, can we say it's a public right-of-way as a town? Can the town tell us that? Can Ron, can you tell us that it's a public right-of-way? The evidence suggests that it is. We haven't seen it.
Well, we've heard two sides that say, one says one thing, one says the other.
That's why I'm asking, what's the town's position, the staff?
I can't make a determination on this until it's clear.
See, I'm willing to hear it. I mean, I think you know my position. If it's a public right-of-way, then I want to see it improved. I want the sewer in the middle of the road. I want all of that. That's where I'm starting from. I'm willing to go forward on that, on the premise that the town has evidence to support that it's a public right-of-way. But that's going to be my position. And then if it changes afterwards, so be it. It changes. The court may rule differently. But if they don't, if they maintain that the evidence we have is a public right-of-way, then I'm prepared to make my decision based on the fact that it is, and that they have frontage, and that I want to see them improve it. That will be my.
I think that's a dangerous precedent. Any application that comes before us, the applicant can say the same thing. If you want us to vote on this, I'm telling you now, I'm going to vote negative until this matter is cleared up.
Well, if that's the case, so be it, because this is going to be appealed by one part or the other. So we need to have this has got to come to a head. We can't kick the can down the road until April and still be in the same position.
We can't act on item 5.
I agree. You're going to be in the same position come April, that you're not going to be able to make a determination because there is no basis for you to do so. So one way or the other, this has to move ahead, whether you grant the application and the objector can appeal, and even the zoning board, hearing this on an appeal is
Right.
not going to be able to resolve that issue of whether or not this is a public or private road.
Yep.
My position is that Mr. Wolanski has reviewed the submission. He's the official planner. He was satisfied when he accepted it that it is a public road.
Yeah, and we can't deny it without hearing their testimony.
I'm going to object to any characterizations that Mr. Wolanski made or didn't make. He's not here to testify to that. It's inappropriate.
Right now, we have to rely on what our solicitor is telling us. And what she's saying is we cannot make a determination.
And just so the record is clear here, it's my understanding that Mr. Wolanski has not reviewed the material that was submitted by Attorney Martland or Attorney Lynch today because he's sick.
Well, that's easy.
And he's not here tonight, so.
So he doesn't.
That's easy. So we don't know that
Yeah.
staff has said, so we don't, so we're at a disadvantage here, like you said, because town staff doesn't have an opinion on it at this point.
Rather than prolonging this and making it any more complicated than it has, I just did speak with my client. We are agreeable to a continuance. We will attempt to work with the objector to see if we can come to a resolution on this. So
Do you
we
wanna
were requesting a continuance to
Continue
the
it
April
to
meeting.
April 8th or
May.
May or
Let's keep it to April,
April 8th?
yes.
I'll make the motion, but I'd like to have discussion.
And just prior to that motion being made, Attorney Lynch, could you also verify that you are amenable to extending the decision deadline that
Yes.
is currently scheduled for tonight?
That's right. Since we are requesting the continuance, we agree to waive any deadlines that are imposed.
May I have a motion to continue this item to the April 8th meeting?
So moved.
Second.
Motion's made and seconded to continue this item to the April 8th meeting. Is there any discussion?
Yeah.
Yes, Bill.
Yeah, I just want to be clear that I think the fact that Ron has not had a chance to review the documents is important here, to note that once he does review it and can make a determination and tell us in his professional opinion that it's a public right-of-way based on his consultation, whatever he has to do, that's all we have to work with. Now, whether we agree with it or not, whether we agree to go forward or not, they're right. They're entitled to get a decision from us, whether it's for or against. So that being said, my position's out there. I was willing to go forward, and I still will be willing to go forward based on Ron's his decision, or his what he sees as the evidence in front of him. If he tells us the right of way, then my position is I want to see it improved. The board feels differently, then we go and we can deny it, approve it, whatever, and then they can do what they want to do. But we need to move it because it's been certified complete, or will be certified complete.
I would add to that, I think that's incomplete. I think the opinion of the planner is important. I also think that the position of the town solicitor to confirm the planner's decision is important to us also.
I disagree with that.
Well, I agree with Mr. Weber on that, so. At any rate, we have this motion. Any further discussion to continue this item? All those in favor say aye.
Aye.
Opposed, nay. The item is continued. Thank you.
Thank you guys for working with us.
Next item on the agenda is item 5C, a public informational meeting, application of Juan Campos for master plan approval of a 5-lot subdivision, including extension of an existing town road, and request for waivers from certain provisions of Article 5 and Article 6 of the Middletown Rules and Regulations regarding the subdivision and development of land. The applicant is requesting that the board consider approval of the conventional subdivision design rather than a 7-lot conservation design plan. The property is located at the end of Serenity Drive with frontage also on Maidford River Road and is identified as Tax Assessor's Plat 120, Lot 68A and 68B. Mr. Jackson.
Thank you, Mr. Chairman, members of the board. Good evening. J. Russell Jackson, the firm of Miller, Scott, Holbrook, and Jackson, on behalf of the applicants, Mr. and Mrs. Juan Campos. As you know, I started to give you a little bit of background during the last meeting, and a potential notice or procedural issue was identified, which, to my understanding, has been remedied since the last meeting. So I'll give you a little background about the project itself, discuss what we've accomplished since the last meeting, and at that point, I certainly will make the applicant available if there's any particular questions that you may have for the applicant, and then I'll let Lynn Small give her description of the project as well. The applicant currently owns lots 68A and 68B on Plat 120, so those two existing lots constitute the subject property, the property which is the subject of this proposed 5-lot subdivision. The total square footage of the land is 406,473 square feet, of which it's been determined 325,610 of that is developable land. The property is in the R40 zone. The applicant is seeking to subdivide the property into a 5-lot conventional subdivision plan. Mr. and Mrs. Campos intend to use, I believe, the largest of the proposed lots as their primary residence. It's their desire to hang on to at least 1 or 2 other lots in the subdivision.
Mr. Jackson, could you hold on a minute, please?
Yes.
May I have a motion to open a public hearing? Public information.
So moved.
Second.
Motion's made and seconded to open the public information meeting. All those in favor say aye.
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 Opposed, nay. I'm sorry.
That's
Please
all right.
proceed.
Thank you. Mr. and Mrs. Campos intend to build their primary residence on, I believe, the largest of the proposed 5 lots. It's also their desire to hang on to an additional 1 or 2 lots in the future, with the idea that over time it will essentially develop as a family compound. The remaining parcels they would likely sell off either as raw land to let a buyer build, or they're also giving consideration to building and then selling 1 or 2 lots thereafter. As you know, there was concerns about whether or not notice was sent out adequately, and that was raised at the last meeting. So since the last meeting, we did receive confirmation. I'm sure you've got a copy of the memo too. Memorandum from the Planning Department from Ron Wolanski dated February 19th, 2020, indicating all of the departments, entities, municipalities that have received notice of this proposed subdivision, and I believe the memorandum satisfies the requirements under the ordinance and indicates that the town has met its burden regarding notice to any potential interested parties. The other issue that was discussed since the last meeting was, since the ordinance requires that an application for a major subdivision submit a conservation plan first, and that the planning board give consideration to that before the planning board considers or approves a conventional plan, the applicant has provided a proposed 7-lot conservation subdivision plan consistent with the yield formula set forth in the ordinance. For purposes of illustration, the applicant has also prepared and submitted a 7-lot conventional plan. And the reason for that is because we want to be able to demonstrate that the max density of a conservation plan is no more than what would be the max density on a conventional plan. So we gave those 2 7-lot plans to the town as well to serve as both our required submission on the 7-lot conservation plan and also serve as illustration that the max density that we're suggesting is appropriate. Now, taking that into consideration, we're asking the board to review those in light of the fact that, again, we are asking for a 5-lot conventional subdivision plan. So all 3 plans, the requested 5-lot conventional plan, as well as the 7-lot conservation and 7-lot conventional, were reviewed by the TRC. We attended a TRC meeting. I know even though that wasn't specifically requested from us last meeting, we did suggest that that may be appropriate to make sure that, you know, we've run down all our due diligence before we come back here again. So we did that, and it's my understanding the TRC, and it's reflected in Mr. Wolanski's memo to the planning board, has given a positive recommendation, and they suggest that any issues that would need to be ironed out through the preliminary plan process would be similar between the proposed 5-lot conventional plan or a 7-lot conservation plan. We also, 2 nights ago, we were before the Conservation Commission. And again, the plan was reviewed. The alternate plans, I think, were reviewed as well. And at the conclusion of that hearing, the Conservation Commission also gave a positive recommendation to the proposed 5-lot conventional plan, and that recommendation included some suggested conditions. Mostly the Conservation Commission, I think, was focused on inquiries regarding water and sewer utility service to the 5 proposed lots. Since we were here last, we also reached out to the City of Newport, and we had a meeting with the Newport Department of Utilities, and we confirmed with the director that municipal water is available from Compton View Drive. We presumed that at the last meeting, but we hadn't met with anybody from Newport as of that date. So we met with the city, we reviewed the proposed subdivision, and they confirmed that municipal water is available from Compton View Drive. It can be brought down Serenity Drive to service the lots that are being proposed in this subdivision. So I can, even though I know we're still just at the master plan stage, I can confirm, though, that my client, after meeting with the city, has made the decision that they will service this proposed subdivision with municipal water and municipal sewer. And I think that's an important distinction because I think wells are still referenced in Mr. Wolanski's most recent memorandum to you. So I wanted to make sure that you were clear that, again, recent developments over the last couple of weeks, we've had that meeting, we've confirmed, and my client has confirmed that they will move forward with municipal water. As far as the 5-lot conventional plan goes, I just wanted to point out, and it's reflected in the memorandum, the proposed lots meet all of the dimensional requirements of the R40 zone. Through the testimony provided by Ms. Small as to the site, the project itself, we believe that there's ample evidence to indicate that the proposed less dense 5-lot conventional plan with a more narrow roadway, that's the one waiver we're looking for, and a shorter roadway, which will then have less impervious surface on the site, in the long run serves to as a better development for the neighborhood, for the wetlands, which are to the east, and for any other environmentally sensitive areas to the east towards the Maidford River. And then lastly, I'd point out in terms of, again, indicating that the proposal by the applicant is something that's less burdensome for the infrastructure of the town, less intense, less dense. I wanted to just point out and remind this board that even though you're charged with looking at conservation plan versus conventional plan, I did want to point out in preparing earlier today and looking through the code, the conventional plan under the zoning code in the R40 requires that it's a single-family use. So that's allowed by right. And we would argue the residential use, single-family, those are all things that are very consistent with the comprehensive plan. The code, interestingly, if it's a conservation plan, allows each structure to be a duplex. So I only bring that up because if the concern is that somehow a conservation plan is going to be less intense, it's going to be better for the neighborhood, it's going to be better for the environment, I just want to remind the board that the conventional plan only allows us single-family use, and that's the intent here. Conservation plan, although the lots may be smaller, although there may be a lot dedicated for open space, I would suggest that the code opens the door for two-family use on each one of those lots. And I think that that's not something that's not desired by my client, it's not appropriate for the site, and it's one more indicator that the 5-lot conventional plan is what's appropriate for this project. So with that, I'd be happy to answer any questions. I'd be happy to make my client available for any questions, or in the alternative, we can just move forward. I know Lynn is prepared to discuss the project as well.
Comments from the board? DJ?
Yes, I believe that there are some members of the board here who would reflect back a few years that the Serenity Drive area came before the board, and it's that first house that we're looking at here. Pardon?
Johnson's.
The Johnson, thank you. It's hard to visualize this. And that the person who was the developer of it said that there would be no building near the Maidford River. And I don't know how many members of the board remember that was one of the questions. And I remembered it because I'm very concerned about the waterways in our town. So I don't know if that needs any clarification. I don't know who the developer was of that first house, but that's the information that we were given at the time. And that was a few years ago, of course.
I do know I discussed this topic with Mr. Wolanski earlier in the process, and he shared with me a decision of the planning board, and it was a 3-lot subdivision, and the easternmost lot was required to be conveyed to the Aquidneck Island Land Trust, which my understanding was, and the 2 remaining lots, were retained by the developer. There was nothing in that planning board decision which prohibited further subdivision or development. It's one of the first questions I asked Mr. Wolanski when I became involved in this project and understood that there were objectors, and one of the objectors was the Aquidneck Island Land Trust. So I'm not aware of any prohibition to further develop subdivision of this land, and frankly, if there were, Mr. Wolanski's pretty good about pulling the history, the zoning and planning history on a parcel when he accepts an application.
Mr. Chairman, I might also echo that if there were any actual restrictions placed on further development of that property would have to be in the decisions of the board approving that subdivision. So to the extent that they're not in that final decision, then they really don't exist.
Yeah, and I think anything that was within the parameters, the term near doesn't mean much to me in Mayford River. If it's Water Protection District 1, that would be a different issue, but I don't think that application way back when like that was a problem.
Other comments?
I do have questions for Lynn when she comes up, but just to clarify, the, apologize, the subdivision is going to have both water and sewer,
Correct.
all lots.
Municipal, all lots, water and sewer. And to be clear, when we bring in the water, one of the requirements, as you'll see from recommendations from the TRC, is that we'll have a fire hydrant down in the
Okay,
cul-de-sac
and
as well.
Are you at liberty to disclose to us the lots that the owner is wishing to retain? You mentioned the owner would take one lot, the biggest, that to me looks like lot 3, but are they looking for also lot 4 and 5, or 1 and 2?
Yeah, I will, when Lynn is speaking, I'll confer with them and I'll come back and report to you, but I agree that Lot 3 is the one, my understanding, that my clients intend to build their primary residence on.
I mean, the only reason I ask is, I mean, you don't have to tell us which one, obviously, but I'd like to know because there are abutters on either side of that potentially might like to know that they're probably going to see like you said, they're going to retain it and hold it hopefully for a family compound, and they'll likely remain undeveloped for a period of a few years before that all happens. So I'd like to know maybe for
Sure.
abutters that might be here.
Yeah.
Other comments?
Mr. Chairman and members of the board, so as the planning board's representative to the Conservation Commission, I sat up here on Monday night and went through the master plan presentation that you had prepared for the Conservation Commission. So, and Lynn, that was just 2 days ago. So, I mean, one of my questions back on Monday night was, in evaluating these different scenarios, conservation versus conventional, 5 versus 7, there was a pretty heightened focus on the percentage of pervious to impervious areas. And I know, Lynn, you didn't have that information available back then. That would have been, and still I think remains would be very helpful in our evaluation of the different scenarios. But we determined on Monday night in making a decision that less is more. We believe that the 5-lot conventional certainly had visually a lot more pervious area than impervious. The shortened roadway in terms of its width and its length was determined to be a benefit, and we were very strong in stating that any connection to municipal water and town sewer would have to be adhered to. So, brings us to where we are tonight.
Thank you. Thank you for those comments. Other comments from the board? I have 2 comments.
Yes, sir.
The first has to do with the roadway width. I just point out that the town council rejected a proposal from the planning board to reduce roadway widths to 20 feet. So I am reluctant, I'm not totally against it, but I'm reluctant to go down to a 20-foot roadway width. So I ask you to consider a 22-foot roadway width. Secondly, my second comment is this. I noticed when I compared your 7-lot conservation plan with the 5-lot conventional plan, that the house on Lot 3 is closer to the water district than any house in the conservation plan. And that just seems to be counter to the purpose of trying to protect wetlands. it seems to me you could move the house on Lot 3 just a short distance, make the driveway just a little shorter, and you would be the same distance away from that water field. So I would ask you to consider that also.
Just
Any
so
other
we're-
comments from the planning board?
So I do have some technical questions, but I'll wait for Lynn.
Sure,
to
so the
make-
only comment I make to that, Mr. Chairman, is I certainly will discuss that with my clients, and just so we're clear, I mean, the siting of the structures on this plan are really more for illustrative purposes as opposed to being indicative of exactly where the house will be constructed.
I understand, but we've had people come back after we grant master plan approval and say, you already approved this, that's why I'm raising it now.
Okay,
So that's a good point. I mean, I was going to bring this up, but I'll ask you because I think that's a very, very good point. That house cuts right through stone wall. That's the existing stone wall that's on the site. So at least, I'd like to know, and then if you look at the stone walls, they pretty much go right through all of the infrastructure that's in there. So I at least want to make sure, I know that you're bound by the ordinance or to maintain them to any degree, any cutting that you do, anything you do with the stones, but I guess I'd like to ask, number one, what would you be doing with the stone walls? Obviously, you have to comply, and I think we need to make that a condition, Peter, of the, assuming we give an approval, that the stone walls, obviously, they have to meet the ordinance, they have to comply with the ordinance, but I'd like to know, at least maybe you can address as in the testimony, because Paul brought it up, if you slide the house forward, then you might be able to maintain that stone wall there. I know it would be close to the house, but I mean, they are stone walls, and they are, if it's in decent shape, and I don't know because I don't recall being out there to see it. We weren't that far out
so,
there.
I'm sorry, Mr. Nash, which parcel are you?
Lot 3, proposed lot number 3.
Okay,
That stone wall looks like it cuts right through where the theoretical house is proposed. But if you were to slide it forward, stay within the zoning allowance, you might be able to save that stone wall. Or at least save a portion of it.
okay. I will discuss that with the client. Thanks. Why don't I turn it over to Lynn now, and she can go through some of the engineering plan aspects of this, and then we'll be happy to answer any other questions.
Good evening. I'm Lynn Small, Northeast Engineers, 6 Valley Road. As Russ indicated, we're working on a 5-lot subdivision of the existing lots that are at the end of Serenity Drive. We did prepare a conservation subdivision for 7 lots and then a maximum yield plan for your review. As far as the length of roadway differences for those different options, the shortest roadway is the 5-lot subdivision where we ask a waiver of the board to construct it all the way to the end of the right-of-way. You can reduce the impervious surface to just a 400-foot-long roadway. So you do get that added benefit of doing the conventional 5-lot subdivision with the shortened paved roadway. It's a 5-lot subdivision. We have wetlands on the eastern side. They're buffering the Maidford River. The 200-foot offset from the Maidford River falls within the wetland area and is east of our property line. So we're not within the watershed protection district for this project. We are subject to permitting and review through the RIDEM for wetlands and for RIFTs. So this will, if we get approval tonight, we'll be going to design, doing the drainage design, all the grading and everything, and then go into those state permitting where they'll review the stormwater mitigation and limits of disturbance and everything associated with the site. We do ask for a waiver from roadway width to bring it narrower, but on this project we are extending the sidewalk that exists on Serenity Drive to our development on one side of the roadway and around the cul-de-sac to provide sidewalk frontage to each of the 5 lots. I don't know if that's a term, but Also, one of the other things that we added to the plan are street trees. We intend to do street trees along the paved right-of-way. And we did manage to get a meeting with Newport Water to discuss the project and the feasibility of getting a water main extension. Water exists on Compton View, and the Department of Public Utilities is receptive to a water main extension. They did ask that we add a hydrant. Its exact location will be dependent on the fire department and the Newport Water Department. There's code separation requirements. With the 5-lot conventional subdivision in the shortened road, I believe it'll be at the end of the cul-de-sac. Newport Water also asked that when we create the sewer line easement going through from this project into the Madeford River sewer manhole that exists there, the Madeford River Road sewer manhole that exists there where this sewer main will tie in by gravity, Department of Public Utilities asked that we include in the language in that the water department could loop their water main through should they ever need to, for any reason. She doesn't need that loop right now, but she wanted us to reserve her that right if Newport ever felt it was necessary to loop that through. That would require that we abandon or remove the existing sewer main that was installed as part of the previous development that runs along the western portion of the property. We also talked to some of the neighbors and will be replacing the wall that was broken down when they put that sewer main connection in before. And that will help with some runoff that runs through that gap right now.
Where's that? Can we?
The previous developer had a sewer main extension approval on the western side of the property, which tied into Madeford River Road. When they built it, they took the wall out in that section. So we're gonna put that back. Otherwise, as far as the walls are concerned, we will survey locate them as the next step in the project, and then be able to answer your question on how much linear feet of wall we have, how much linear feet of wall we're interfering with, and where we may make up for that on the site. That makes sense with the proposed development.
Lynn?
I'm sorry?
You were saying that, just wanted to see if I can get this straight, that that water line that would come in from Compton View, that would come down that easement, that easement right now on the, I guess it's on the west side?
No, we would, so if you look at our, let me see. If you look at sheet 3 of 12, you can see, we would bring the water main's not shown at this time because we developed these plans before we were able to sit with Newport Water. But if we're gonna bring the water main in, we'd bring it in down Serenity Drive to the end of the cul-de-sac and then turn south and go down the easement that's between subdivision lots 4 and 5, which is where we have the sewer line easement. I discussed this at the TRC with, and Tom O'Loughlin mentioned that in that case, he would ask that we widen that easement from 20 feet to 30 feet. That revision will be made on the next set when we submit that to you. But the site generally slopes all towards the wetland area, so from a stormwater perspective, we'll be capturing that, providing your water quality treatment, your detention, and then releasing it towards the wetland areas that it goes to today. I did talk to the homeowners, and they had mentioned that if they were able to retain 3 lots, which is their ultimate goal, it would be lots 2, 3, and 4. Which are the ones on the lowest end of the site.
2, 3, 4,
I
and
don't
5?
know.
3, 4, and
2, 3, and 4.
2, 3, and 4.
Okay.
I don't know if you have any other questions. We do have municipal water and sewer.
Any questions for Lynn?
I'd just say how delightful to have a subdivision with sewer and water for a change.
Bill?
Yeah, I have a couple of questions, Lynn, thanks. Just a housekeeping thing, I guess it doesn't matter what sheet, but you're showing the ownership of the Ocean Ridge Owners Association. There's a hatched area inside the existing draining basin. You see it there? Looks like it's hatched out for some reason. Look, that's a property line.
Are you talking along the western property line of the
Correct.
project site? That's supposed to represent the existing sewer easement that will go away as part of this project.
So, no, but I'm talking about AP 120 Lot 71.
Yep.
That's the open space for the
The drainage basin for the
drainage basin.
adjacent development, yep.
And that includes the rest of the lot around it?
Yeah.
The lot beyond. So I just think it's a little confusing in my eyes. I think
Oh.
it doesn't show any ownership beyond that. To me, I would say that looks like a lot of ownership in there, and it is, but it also includes the rest of the area, which I think is important to note.
Oh, because we have it inside the basin.
Inside the basin.
I gotcha.
So
We'll
that's one.
move that.
And
Okay.
thank you, the sewer easement to be eliminated, the easement's going to be eliminated, and the sewer line that's in there, there's actually a physical sewer line in there.
A 6-inch diameter.
It's just gonna dead end, it's gonna be.
So Tom is gonna guide us on what
Okay.
he wants for that. He does want it, it's not gonna be just abandoned.
Right.
He doesn't want anyone accidentally connecting into it in 20 years. So
that's
he
what I
wants
was-
us to either fill it or take it
Yeah.
out, but he hasn't
Okay.
decided exactly which way he's gonna go on that
Just
yet.
wanna make reference of that, so they know, I mean, obviously you know, but I wanna come back to that. And you addressed the stone walls for me. The only other item that I have a little reservation on is the transition of the road. I'm not crazy about a 20-foot wide roadway. I think you're aware of that. The existing road at Serenity Drive looks like that's 22, or is that 24? I don't like the transition from existing Serenity into the extension. It just seems awkward to me.
I think it's 22-foot clear, existing Serenity is 22-foot clear with a berm on each side. And then, right, what we have shown on our plan for the extension is 20 feet clear with a berm on each side.
So to me, that's awkward. That's an awkward transition. If I'm driving it to and from, the roadway all of a sudden shrinks, or it all of a sudden gets wider. I guess that's a good thing, but it just seems like an awkward transition. Maybe flaring it there would be, flaring it to the existing. I think that's something that is uncomfortable for me, but really what it more relates to is the change that you have gone from since last meeting to remove the circular driveways that I liked.
Well, we are gonna add notes onto the plan, similar to projects that we've done elsewhere in town, where we make sure those driveways are approved by the fire department. What's a little bit different with this subdivision than some of the other ones where we added those notes is that we actually have a municipal roadway. It's a public roadway with a cul-de-sac, so the fire department doesn't actually need to go all the way down their driveway to.
Yeah, that's not my concern. My
Oh,
concern
I'm
is,
sorry.
is the transition into a 20-foot wide roadway, which is awkward for two-way traffic. I know it works, but when you don't have allowances at these long driveways, and that's what they are, these are long driveways. If you don't have allowances to park cars there, they want to stay down in the cul-de-sac, particularly lot 1 and 5, they want to park along the roadway, which creates further restriction.
So the owners have since agreed to widen that to 22 feet to match Serenity.
The road, okay,
Lot.
so that makes me feel better. So
Serenity.
I feel better about that.
Okay.
And I do like the circular driveways, but there'll be a note that the TRC can review. But I guess generally, why did you remove the circulars from previous plan? Just because, or was there?
Yeah, there was a lot of talk about them, that they were misleading, and we didn't want people to, these are really just placeholders. When people go and build their house, they're gonna have a house with their driveway. Most houses we're seeing in this kind of development have a courtyard, because they want to give their company places to park, so
That's my concern.
this is just, yeah.
With the wider road at what currently exists there, I feel better about not having areas for guests to park, so I'm better on that, so thank you for that answer.
Okay.
I'm good, thank you, Mr. Chair.
Other comments?
So, Mr. Chairman, if I could just follow up on a couple items with Lynn. Lynn, if you could...
Could you speak at the microphone, please?
Sorry.
That's all
I
right.
just wanted to follow up with Lynn to get a few more details on the record, and mostly because I know you need to take an affirmative vote first on the conservation plan before you move on to the conventional plan. So I was hoping maybe, Lynn, if you could, I know we've discussed in detail the proposed 5-lot conventional plan. Maybe you can give a few more details to compare and contrast what the applicant is proposing versus the alternative conservation plan, and what perhaps some of the pros and cons would be of moving forward with the conventional plan.
Sure. So on sheet 10 of 12, we have a 7-lot conservation subdivision plan. This provides you maximum density for the project. We end up bringing in Serenity Drive all the way to the end of the cul-de-sac to provide access to each of the individual properties. It ends up being a longer roadway than what we're proposing with the 5-lot conventional subdivision plan. We do have a higher density, obviously, with the 7-lot subdivision versus the 5-lot subdivision. Basically, I guess the biggest differences that you have, I mean, as far as proximity to the wetlands, the 7-lot subdivision gets pretty close to the wetlands, and then the drainage feature will be basically where we have it for the 5-lot subdivision. So there's not a huge benefit in the way the open space works out for that project. For the 7-lot conservation subdivision, we do keep the municipal sewer, and I do believe we should be able to get that to still work by gravity. For the purposes of comparison, I suppose we should assume we would also bring in municipal water, just to be fair. But from an environmental perspective and the protection of the wetlands and eventually Maidford River, although we're hundreds of feet away, the first step in a green development is to minimize impervious surfaces. So 5 houses versus 7 houses, 400 feet of road versus 550 feet of road, all of those things add up to an improvement to the environment. So for those purposes, we'd prefer to go with the less dense 5-lot conventional subdivision with the waivers from extending the road for the full length of the right-of-way. For what it's worth, the shortened roadway on the 5-lot subdivision also allows, we put that house further back on that one subdivision lot 3, but when the roadway ends 100 feet short of where it's supposed to go, it's going to be a lot easier to bring that house closer.
Yeah, right.
So we can bring that closer towards the front setback,
Yeah.
and it won't feel like you're right on top of the roadway.
Maybe save a wall.
I'm sorry, and maybe save a wall. We'll add those to the plan so we can see how they lay out. So,
Any other comments?
Just a couple more follow-ups. So Lynn, as far as the findings that the board needs to reach in terms of this, in terms of requesting their approval of a master plan. Now, you've been in front of this Middletown Planning Board many times,
many
correct?
times.
You're a civil engineer licensed in the state of Rhode Island, correct?
Yes,
All right, so the testimony you've given has all been within a reasonable degree of professional certainty as a civil engineer, correct?
yes,
Now, as part of your work, you're obviously familiar with the Middletown zoning code, is that right?
yes,
All right, so in this 5-lot conventional subdivision plan is compliant with the standards of the Middletown zoning code, is that fair to say?
yes it is.
All right. Now, you're not a land use expert per se, but in your line of work, you're also familiar with the comprehensive land use plan of the town of Middletown, correct?
Correct.
Was there anything involved in this 5-lot subdivision which appeared to be inconsistent with the comprehensive plan?
No, not in my opinion. It's residentially zoned, residential uses all around.
As has been discussed and you've testified, this 5-lot conventional plan is going to have municipal sewer and water, correct?
Correct.
So that would it be fair to say that mitigates most of the significant potential environmental impacts to the site?
Yes.
And in what other ways would this have no significant negative environmental impact on the land?
Well, the shortened roadway, the reduced impervious areas, and the stormwater designs that we'll be preparing will help provide pre-treatment, water quality treatment, and mitigate any peak runoff, so we're not overloading Meadford River.
All right. And we're not creating any lots here which have any physical constraints to development on those lots, correct?
No, correct.
And then lastly, all the proposed lots and the land development have frontage on a public street, correct?
Correct, on a public right-of-way.
Thank you. Any other comments from the planning board? BJ?
Yes, I would like to know the opinion of the Aquidneck Land Trust, what their feelings would be for what you've explained to us. Have you heard anything from the Land Trust?
The Land Trust is represented by council, and they're here, so you can hear directly from them.
Yes.
Thank you. David Martland, here on behalf of the Aquidneck Land Trust. I'm also representing Paul and Hetty Bennett. The Bennetts unfortunately could not be here as they are presently traveling. My clients are both very concerned about stormwater runoff issues, the impact on the wetlands, and the impact on the Meadford River. Some serious concerns relative to those issues. Now, I know that you don't typically get into those issues at the master plan stage. However, there was testimony tonight from Ms. Small that there would be no significant negative environmental impacts on the property or to the adjacent property. You know, I don't know how that can be stated when the stormwater hasn't been designed. This hasn't gone through.
Why don't we wait till we get the information and then we can evaluate it? I mean, it's
That
all.
happens at no preliminary.
I understand, but I think if I understood some of the testimony was to try to establish that there was no negative environmental impact associated with the stormwater. I want to make sure we reserve our rights on those issues.
They will be evaluated during preliminary.
I would say for the record, the board right now has no information in front of it on which it could make any such determination as to the environmental impact, because we're at master plan and there is no engineering that's been provided. So the board's not going to make a determination on that issue now, and all parties are going to be free to raise those issues at the preliminary stage when that's the appropriate time to do that.
Thank you.
I'm sure the concern is noted.
Yes, duly noted.
Thank you. There was one other issue, and I'm not certain it matters, and it dealt with the yield formula, but Mr. Wolanski's not here to ask him
We
a
have the
question
solicitor.
relative to that.
We have the solicitor.
Next best thing.
But-
We got his replacement too.
That's-
He counts for
I'm
something.
not sure I agree with that statement. So,
And maybe if you might want to ask, Ms. Small about the calculations. There were recent amendments to the way you calculate the number of lots, and I wasn't sure which formulas were utilized, whether it was the old formula or was it the newly adopted formula in calculating.
Well, I mean, after the amendments, there's only one formula to be used.
there is only one effective formula. You may want to, if the board wishes, they can ask the engineer
Which
whether she
formula
used
was used?
the current one.
Yeah, we asked that question. We're asking.
Can you tell us which formula you used in determining lot size?
What we, to determine the maximum number of lots allowed on the development, we took out the developable land, we took out the undevelopable land area under existing conditions, which is your wetlands and your utility easements. And then, wait a second, let me just get to that sheet.
Well, the issue that is being raised, I believe, is whether you use the formula that remained after the yield plan was eliminated. Remember, the town council passed an amendment that eliminated the yield plan approach to determining lots,
And then we were asked to do a yield plan, right?
Well, there's
Well-
the yield formula under section 304, which sets the basic maximum number of lots.
So you take the total land area, you remove the undevelopable land area. For this project, we had a right-of-way, which was the head of a cul-de-sac at the end of Serenity Drive for the 2-lot subdivision and the wetlands. And then you take 80% of that and divide it by the underlying zoning area, so 40,000 square feet.
which I believe is the formula that is current.
And that yields 7.2 lots.
I thought that had been changed to 48,000 square feet in the R40 zone.
I don't think so.
I don't, I'm not sure where that comes from, Dave. I know,
In the recent letter?
that number doesn't,
I don't think we changed that number.
that number doesn't ring a bell to me.
No.
Well, you used to take 80%.
Yeah, we still do.
I thought you stripped that, and now it's 48,000
No.
divided by. At least that's the email.
I think, Ron, if you're watching at home, can you answer that for us?
Oh, a solicitor is madly digging.
I know, maybe digging.
And if I might just ask another question.
Sure.
Lynn. I'm sorry, it's really difficult for me to read these.
Get closer to the microphone, though, please.
Yeah,
Increase the,
Dave, move closer to the mic.
I was trying to, keep this appropriate social distance.
what's the virus? I get it, the virus. All right, that's a fair statement.
The area of public rights-of-way that was removed on sheet 10 indicates 8,000 square feet. Is that correct?
Yes. 3,630.
But on sheet 12, the street right-of-way is shown as 25,000 square feet.
That's
And it just seemed like a large difference to me between the.
so the way the conservation development the conservation subdivision yield calculation works is the developable land area of existing conditions is used in the calculation. So we had to take the head of the cul-de-sac that was done by the previous developer out of your developable land area and the wetland on the site to come up with the number of lots. The 25,000 square feet that you're seeing on the conventional, when you do a conventional subdivision, you have to take out your proposed conditions undevelopable land area. So that would be the same wetlands, but now our road is bigger. So that's a bigger right-of-way that needs to get removed. Does that make sense?
So we're talking we're not talking an awful lot of area here, so something that can be addressed by the planner as a condition, just to be clear. I mean,
I don't want to hold up anything. I think it's a question out there relative to
calculation.
The maximum number, I think there was a change, I believe the change indicated that when you calculate the number of lots, you now take the developable land area, and additionally, you back out the street rights-of-way that are proposed, but
So
Yeah,
what-
I don't think
that's-
that.
let me just be
that's a
clear,
recent
whatever it is,
change.
I'm willing to go with the condition that the town planner verify the calculation.
Yes, I am also. Yeah. I think we can move
Yeah.
forward with
Yeah.
that. Any other comments?
I was just wondering,
BJ?
the Aquidneck Land Trust, that was not answered. My question about the,
I think he did indicate that they had concerns
all
over,
right,
if I wrote it down correctly, he
Right,
said
did
they
you
had
write it
concerns
down?
of stormwater runoff,
so
the effects
there
on
are
wetlands in the
concerns.
Mayford
Okay.
River.
Yeah,
All right.
and in particular, the Mayford River, which is designated as an impaired waterway and
Right.
is part of the
Right, I just wanted to
drinking
get
water
part of the record.
resource. Yeah,
Which runs through both of your clients' properties.
that's correct.
Other comments from the board? Is there anyone from the public who would like to comment on this?
Good evening, Mr. Chairman, members of the board. My name is Bruce Cox. I'm an attorney. I'm also the son-in-law of Harold Perlingero, who owns Assessor's Lot 222, which is one of the two lots that abut the property to the south. I'm also here on behalf of Maria Patricio, who is the lot to the west. They're equally concerned about water runoff. We've spoken with the engineer to some degree, and I know that that will be addressed in the preliminary engineering phases of it. We did want to bring it to the board's attention. It was we were grateful to hear their commitment to rebuilding the wall that was torn down by the prior developer when he brought the sewer line through. We can speak from personal experience and from Mr. Perlingero's comment. His northeast corner of his lot is very damp now. The whole grading of the land is about equivalent to a handicap ramp, all the way from the top all the way to the bottom, so 1/12. So it has got the ability to develop some real sheet flow. Ms. Patricio advises me that the drainage pond that's behind her house, immediately to the west of her house, actually fails and floods her property now. And when the sewer line that's going to be abandoned was installed and not properly graded, and not that the sewer line's out of grade, but the land surface is not properly graded, she's had increased water flow there. So in the preliminary elements, we're going to ask that you pay particular attention to that sheet flow design, that sheet flow element. While there are detention ponds over in Lot 4, there's nothing addressed over here in the southern corner. And as a final element, it was great to hear that they're going to bring water in off of Compton View. That'll be a great help for the neighborhood in general, which is relying upon wells. But the question could be asked if the water line could be brought down when the sewer line is brought down to tie in. It's going to be a wider easement so that two things could occur. So a water line would be at the head of Mayford River Road there, at its northern terminus, and perhaps a fire hydrant placed there, because the nearest fire hydrant to fight fires in that area is at the eastern terminus of that's the Paradise Brook Farm Road. So those are the primary elements that were of concern to these two particular abutters.
Thank you. I don't, sure.
So so that easement that you talk about, Bruce, at the proposed easement for the sewer.
Correct.
But also potentially for the water, but that's not the plan to go through there yet.
No, it is not, but if I heard correctly, that the plan is to increase the width of that easement from 20 feet to 30 feet now?
Yep.
Yeah, the city of Newport Utilities asked us for that, to make sure that was available in the event in the future they wanted to run the water line, correct?
Right, if they wanted to loop the water line, 'cause water systems
So
work
you
better
would
when
like
they're
to
looped.
see if they loop it, see a hydrant there? Is that?
I think that'd be an advice. The hydrants are relatively cheap, and the benefit of them can't be understated.
Can we make that a condition? If they loop it, that we,
Yeah, once again, this is something that would be discussed at the preliminary
Okay.
stage.
Yeah,
right. Okay.
Once the applicant provides the full engineering design as to where those lines are proposed.
So I would then suggest to the owner, to Lynn and to the applicant, just keep that in mind, that, I think that's a fair condition to ask. If
Through this process, we will certainly discuss that.
Come to the microphone, please.
I apologize, my bad.
Thought I was being loud enough, but just to make sure if it's being recorded. We will certainly keep that as part of the discussion and the dialogue with the City of Newport Utilities in terms of any potential installation of an additional fire hydrant in the event the city wants to loop the water main to Maidford River Road. Okay, but ultimately, I think that's the City of Newport's decision,
Sure.
not necessarily ours.
I want to say that Mr. Jackson was very professional calling me to remind me of this meeting on Monday, I believe it was. So we just want to bring forward the concerns we have and to work with the applicant, and hopefully not have any worsened conditions occur.
Thank you very
Thank you.
much.
Thank you, Bruce.
Is there anyone else from the public who would like to speak?
I would just like to say.
You gotta come up.
Please come to the mic. And identify yourself.
Edward Brady, 2 Mayfield River Road. I would just like to say that the proposed development, they have worked with the neighbors to ensure that we rectify the problems that we've had in the past. And as a neighborhood in that area on Wells, we are very grateful that they are going to go with city water, because I think you've all heard problems are starting to develop in that area. And this will ensure that this will not cause this problem to get any worse. Thank you.
Thank you.
So that brought up a question, Lynn. The water, is that gonna be will it be in the right of way? Or is it in the shoulder, or will it be in the center of the road? You have to dig the road up from Serenity all the
Yeah,
way up?
unfortunately, Newport Water requests that the water main be within the
Middle of the
right-
road?
Which is why it was so expensive to add to, which is why we had to get the numbers before we could concede to that.
So
But
in effect, Serenity, the existing portion of it is going to get repaved.
half of it, the town of Middletown makes us repave half the right of way. So we have to repave half the right of way.
Okay. Thank you.
You're welcome.
Thank you. Anyone else from the public who would like to speak? We have a motion to close the public information hearing.
Motion made.
Second.
Motion's made and seconded to close the public information meeting. Is there any discussion? All those in favor say aye.
Aye.
Opposed, nay. The public information meeting is closed. May I have a motion for a favorable for master plan approval with conditions on this for the,
So I'll make it.
for the,
And one of the things the board should do is as part of that motion, is to state which
one? Yes,
which one
that's what I was just going to
the board
ask.
is,
Yeah,
prefers.
for the 5-lot conventional plan, proposed 5-lot.
I'll make that motion if that's okay with you all. I move that we approve the master plan approval with the 5-lot conventional.
Conventional.
This is gonna kill me forever going forward. 5 lots, how's that, makes it easy. With as laid out in the memo dated March 2nd, Ron's memo to the board, including all of that they've met all of the required findings, and with the waiver as stated, and the conditions as stated, with the addition of Do you want
Not
to,
to interrupt, just we want to make sure the vote is done procedurally correct in terms of 7-lot conservation versus 5-lot conventional. We're going to confer with the solicitor.
sure. We hold that thought?
Just hold it for now.
Hold that thought. So you think that they've met?
So they could have to do.
Okay. I tell you what.
And they have to make that finding.
Because it sounds like we're gonna have to do a separate motion. You okay with that?
Decide, we can't just say conventional plan, we have to support it with one of these little paragraphs.
Yes, we have to specify.
We have to specify, he's right. I think
Yeah.
you do.
Yeah.
So I think he's good to do it then. So And then I'll make the
Well,
motion
I
for that.
look at it, I think it's 1, 3, and 4. That basis.
I was,
That's what I was gonna
I picked out elements instead of just the whole.
I just do the big numbers.
Okay. So just to be clear, and maybe we can restate the motion after, since I don't think it's been seconded yet, is the
Can we
board-
just make a motion on the plan that we wish to? go-
Yes.
Okay.
You may select the conventional plan versus the conservation plan, but in order to do so, as set forth in Ron's memo, you've got to make a finding
Yes.
that
Which
at least
ones?
one of those statements
Yeah,
are correct,
yes.
and I would
Yes.
like the board to state
Yes.
one or more of
We
those
intend to do
findings
that.
for the record.
We intend to do that.
Yep.
Okay. So may I have a motion?
I make a motion to approve the master plan approval and to support the conventional plan based on paragraphs 1, 3, and
The 5-lot conventional plan.
5-lot conventional subdivision based on paragraphs 1, 3, and 4.
Second.
Well,
Which
with-
paragraphs?
1, 3, and 4. Plus all the other conditions that were mentioned tonight, the 22,
Are those the findings that you're making?
yeah.
No,
Okay,
so-
but those are, the findings are letters, not numbers.
1, 3, and 4 were the were the 3 items that justify it.
My,
Do you mean,
So I think we have to do it in 2 parts.
that's what I mean. I think we gotta do 2 separate motions here. That's what I was getting at.
Yeah.
One for the,
gotcha, okay. Thank you.
Peter, do we have to do, can we do 2 separate motions to make it easier? One to, or should we do it all
No,
together?
you do it in one, that's fine.
Yeah, it says
Yeah.
one or more of the following
Yeah,
statements
so
are
you've
true.
got
There
1,
are
3,
four
1, 3, and
statements.
4 in the motion.
1,
Yes,
3, and 4.
correct.
Okay, so let me, do you want to continue, Art? Go ahead, I'll let you go.
No, I'm fine with my part.
Okay, so I'll restate it then, just to be clear. I'm gonna
Sean,
move,
let's see what Sean has.
move for approval of the master plan on this application, the 5-lot conventional subdivision plan as spelled out in the memo dated March 2nd by Ron Wolanski, town planner, that they're in compliance with items number 1, 3, and 4 of the memo.
Well, not in compliance, that justifies
That
selecting
it justifies,
the
that
conventional plan.
they meet
Yeah.
the standards in 1, 3, and 4. With the requested waiver,
What's the requested waiver?
reducing the road to
No. They agreed to go to 22 feet.
to 22 feet.
Yeah.
Right, to 22 feet. That they meet all of the required findings and all of the 6 conditions as laid out by both the technical review and staff, in addition to.
And in addition, I would suggest that you just reference that you're in favor of the waiver to reduce the length of the road in
Yeah.
addition to the width, and you may wish to incorporate the recommendations of the Conservation Commission.
Yes.
As stated by the solicitor, included in my motion. The additional conditions,
In the Conservation Commission's memorandum of March 9th.
thank you, Peter. But additional conditions beyond those 6 and the conservation relative to the stone wall, that the stone wall is,
I would simply say that they'll comply with the
that's what,
provisions of the stone wall ordinance.
that's what it was gonna be. Yep. They provide the stone wall provisions in the ordinance, that the, I wanna make a note in the master plan that the sewer line is abandoned appropriately with the town, in accordance with what the town engineer requires.
Street trees.
The street trees as laid out on the plans are included, and that the town planner verify the calculation that was done relative to the density.
And that the house on Lot 3 is...
The house on Lot 3 is
The house
moved
on Lot 3 is moved
further away from the
west.
wetlands.
further west as possible.
Yes, yes.
Got all that, Mr. Planner slash manager slash do it all? Do we need to restate that for you?
We got the,
So is everybody on the
we got
board?
video.
Everybody on board okay with the motion?
I'll second that motion.
Motion is made and seconded for master plan approval as stated. Is there any discussion? Any further discussion? All those in favor say aye.
Aye.
Opposed, nay. Motion passes.
Thank you all.
Thank you.
Wow,
Wow, that was a big one.
that's a lot.
That's just some housekeeping stuff.
All right. Challenging.
The next item on the agenda is item 5E,
Yes.
review the final draft of analysis of full build traffic and environmental impacts by Crossman Engineering, and consider forwarding to the town council. Now, on this matter, we got a draft at the last meeting. A final draft was provided digitally, and today we received a list of the changes that were made between the draft that we received and the final draft. And included in the package is a draft memo that can be forwarded to the town council. In that memo, it suggests that the town council request the planning board to establish a subcommittee to work with the planning department, aided by Crossman Engineering, to prepare a prioritized list of recommendations for implementing the recommendations of that report. I would open the floor to discussion to the planning board members. Is this approach satisfactory to everyone? And I would be open to hear any comments on that approach. Mike?
Yeah, I reviewed the latest online version, and I found that the executive summary was, improved. I think it's a good, it's a good summary of the report, and I think it'll be a good thing to forward to the town council, to give them all the recommendations that were in the report.
By the way, I like the idea of forwarding this to the town council now, even though the planning board is not yet ready to make its recommendations, because as you know, this is a sizable report and it will give them as much time to read it as possible. So that's why I think this is a good approach.
I would recommend one other thing we add, because it's probably one of the most important relative to water, is that in the groundwater section, we put in there that the suggested requirement that a wastewater management plan be adopted also. I just put that in there because we're trying to get that done in a different way, but maybe if they see it here.
Let me I saw that and I thought about that, and my feeling was that we should let the town council see this and then act on the wastewater management plan.
But I think in our...
You'd like to see it mentioned in this memo?
In the memo, because I'm kind of keen about getting this done, and I think if they see it there, one of the bullets, rather than buried in the back of the plan, it will bring that to their attention. So I don't know what the...
But is that under groundwater or surface water?
I'd have to go look.
I think it would be under surface water.
Yeah, we'd have to go look. So I don't know what the planner thinks about that.
Look into the camera and ask them.
Let me ask the solicitor and the town administrator, in the capacity as town administrator. If we added a sentence to the recommendations at the end of this memo, saying that once the town council has this report in front of them, they would be better prepared to act on a wastewater management plan, would that be adequate?
I suppose, it's, yeah.
Would that do it for you?
Yep.
All right. I'll draft a sentence and
Okay.
give it
That'd
to
be
you.
great, thanks.
Okay. So is this course of action okay with everyone? I don't think we need a motion.
No, I was just going to add one other item. The Land Trust has a plan that they've completed for Quinnick Island regarding build-out that they're also looking to bring forward to the town council. I've been holding Chuck off, waiting for you to get this plan to the council, so it helps.
Together.
Yeah, sequencing, you know, the different groups that want to come forward to express concerns and ideas about development, not only in Middletown, but across the Quinnick Island entirely. So
Yep.
I think it is a good idea to start moving this. And then I'll talk to Ron about the fact that, you know, the formal correspondence needs to move along quickly also.
Okay, very good.
Good with that?
All right, so I will add a sentence and give it to Sean to give to Ron to modify this memo.
As another thing to support what Sean said, they did have a public hearing, the Land Trust last summer, and some of us went to it, and it was very, very illuminating. And I think our project really adds a little something to that also, to complement it.
No doubt, no doubt.
Okay, the next item on the agenda is item 5F. Public hearing, consider amendments to the rules and regulations regarding the subdivision and development of land to add a proposed section to 523 to require submission and approval of a landscape maintenance plan for subdivisions and projects subject to development plan review. You have a motion to open the public hearing.
Motion made?
Second.
Motion's made and seconded to open the public hearing. Any discussion? All those in favor say aye.
Aye.
Opposed, nay. The public hearing is open. If Ron were here, he would mention that we had already agreed to consider some amendments to require a bond for the first year landscape work. What this does is require a landscape maintenance plan that describes how the landscaping will be maintained thereafter. And it proposes that the tree warden be the town representative who would not necessarily enforce it, but inspect properties to make sure that they were compliant. BJ, would you like to comment? I know you were involved with this.
Yes, the tree commission is very excited about this, and they were in total agreement with everything that was proposed, and our tree warden was most interested and willing and able. So it just needs to be put into practice.
Thank you. Any other comments? John?
I have one question about this, and I, quite frankly, have dubious ideas about this. That once they submit their plan, they go on with it. And the tree warden, I don't know if he's a landscape architect or not.
Yes, he is.
Okay. What if they decide to change their landscaping within 2-3 years?
Good question. Maybe be brought back to the board.
Yeah, they would need to come back to the board. For
Okay.
example, if they're putting in required street trees and things of that sort, they can't simply take them out. They could, I mean, obviously, individual homeowners.
They would
can
have to
add
come
things
back to
and
the-
change their landscaping, but to the extent that landscaping has been presented and required to be part of the plan and installed and maintained as part of the plan, they
But
need
let's
to come
say,
back to change that.
let's say that they decide that the landscaping isn't growing, isn't taking effect, is not what they wanted. Do they have to come back and say, we want to redo this to get permission to do?
If you're simply going to replace trees, I would say no, but if you're going to come back and do something completely different, then yes.
Do they do that now?
Not necessarily. That's one of the
Nobody does
reasons why the intent is to try to increase the ability of the town to make sure that these things, number one, are installed
Right.
according to the plans that come before you, and then that they're actually maintained, because sometimes these things get installed they die after a year.
Right.
And that's it. So the idea is to make sure that, you know, whatever landscaping the board wants or that the
Okay.
regulations require is actually installed and it's maintained and it you know, continues its purpose.
Yeah, good.
Other discussion? Other comments? Is there anyone in the public who would like to comment on this? May I have a motion to adopt this proposal and forward it to the town council for approval?
Do we want to close the public hearing first?
May I have a motion to close the public hearing first? Thank you.
So moved.
Second.
Motion is made and seconded to close the public hearing. Any discussion? All those in favor say aye.
Aye.
Public hearing is closed. May I have a motion to adopt the proposed change and forward it to the town council for approval?
So
Motion
moved.
made.
You make the motion?
Yes, I did.
Yes. So moved.
The motion was made by BJ. Do you second it, Art?
Yes.
Okay, motion made and seconded. Any further discussion? All those in favor say aye.
Aye.
Opposed, nay. Motion passes. Next item is item 5G. Review the revised draft of the proposed airport hazard overlay zoning district and consider scheduling a public workshop meeting. Joe, you chaired the committee. Do you have any comments to make at the beginning?
My comments are that we've spent a considerable amount of time on this, and Mike can weigh in as well, and BJ. I think we're at a point where we really need to solicit the public's input to this process to go much further with it. So we've taken an approach that you know, less is more as it relates to the airport overlay district. And we spent a lot of time looking at other examples, specifically what they did in Westerly, and trying to take some best practices and apply it here. So that's where we're at with it.
Does anyone have any comments on what is being proposed? Then Mike?
Yeah. No, the only thing that we discussed that might be, you know, that could be a problem is the, you know, in the runway protection zone, there might be some existing, you know, trees, you know, that don't meet the height requirements. So I guess we'll have to wait, you know, to see what the state, you know, does, you know, in a similar case in Westerly, to see what kind of options, you know, there might be to either removing them or cutting them down or whatever. So, but as it is, it's good.
Any other comments? Then I would like to suggest that the planning department schedule a public workshop. However, since this is not a high priority item, let's wait until the situation with the coronavirus is clarified. That agreeable with everyone?
Yes.
Okay. Next item on the agenda is 5H, review revised draft documents regarding the proposed Atlantic Beach Overlay Zoning District and consider forwarding to the town council for consideration. Any comments? Comments? I have one comment. One of the things that we discussed at the last meeting was restricting the number of rooms to those that were currently there or currently in the works. And when I looked at the breakout, I would suggest and like to modify that sentence to read, shall be limited to the number existing plus the number in the development approval or permitting process that are already approved at the time of adoption of this section, because there are some in here that may not get approved because of the size.
Well, so, some of that language, the existing here and then what's being proposed is somewhat problematic because, you know, you're, in order for this to be, I guess, enforceable, you're taking a position that the appropriate number, assuming that the board votes to have a cap or suggest to the council that there be a cap, you're saying it's going to be that one number is appropriate, and then we're saying, well, maybe it's a different number or some other lower number, depending upon what happens with these projects that are already in the pipeline. And so that is, I'm concerned that is,
Well, but if
that sort of language would be ripe for a
if
challenge.
we specify that we limit it to those that are approved, then
Well, I'm more comfortable saying that the board takes a number and, you know,
Just
and
pick
not,
a number?
not referring to projects that are approved or not, but say, the board believes that based on a whole number of whatever factors you're looking at, that the appropriate number is X.
So
And that's what we have here. It's not dependent, your determination of what the appropriate number,
so
the
you would
council's
rather we
determination.
just pick a number?
Yeah, I'd rather have a number, if you're gonna put a cap, I'd rather just have the number rather than have some moving target depending upon what happens with projects that are already in the pipeline.
Okay.
Because it's, you know,
So I think regardless of what we do, I think this is prime target for challenging, and it's gonna be the number of units is definitely gonna be an issue, so I don't have a preference. I say pick a number, let's go with it, but I think it's gonna have a
so,
fair
and
amount
I
of
don't have a
challenge.
problem with you saying that the number, the method that you chose, which is to take the existing plus the proposed and call that the number. I just don't want to have the number be a moving target.
Yeah.
Well,
And I think maybe the board, you might want to, the board might want to discuss whether or
Yeah.
not there is support on the board for that change in general.
Comments?
Well, I think if we take what we currently have, and like whatever's in the pipeline, I don't know if it's approved or it's under consideration, but I think that might be the number.
Well, that number comes out to 257.
257.
And my suggestion would be to pick 250, which I think would cover any issues we have with applications coming in that are too big and whatnot.
Well, my concern would be then you're automatically rendering some of the projects, if the projects in the pipeline all get approved, you're automatically rendering some of those non-conforming uses.
Well, all we're saying is if we look at that number, that gives us an idea of what a good number is. And we think a good number is 250.
Yeah, there's documentation suggesting that we asked for this direction. I think we need to go with 257 and take our chances. But frankly, I think that's a provision that's going to get beat up and down at council and with the public again. I believe that you're going to have some pushback on both sides on this.
Well,
but I think
Yeah,
the methodology to get
But
there.
my concern.
Let's remember where this came from, right? We were asked to devise an overlay that would capture the vision of the Atlantic Beach District Master Plan and the Comprehensive Plan. That's what's driving this. It's not a matter of what the market says, or what any developer says, or what a town council person says at this point. It's just what we think a good vision for the Atlantic Beach District is. That's what's driving this at this point.
And I'm
Might
not,
there be pushback? Of course there might be pushback.
and I'm not suggesting the board take one position or the other on this. The only thing I'm suggesting that if you're going to set a cap, not to set the cap lower than what was discussed at the last meeting, which was existing plus currently proposed.
In the pipeline.
Applications that have been filed and accepted.
That's
and
easily
are in
defendable.
front of the boards for consideration.
And that's easily defendable.
Except that some of those have not been approved yet. And they may not be approved.
They may not be.
So,
Possible.
So what I'm saying is that you are taking new developments that are going to be in front of the board, which are automatically going to be non-conforming uses if they are approved. And that
Or
is,
forcing
from
them to have
just
to
from a
get a variance.
good planning practice, that's not an ideal situation.
Or forcing them to have to get a variance.
To make new development that you've just approved a non-conforming use or non-conforming development.
I think we have to go with what's there.
257.
I understand, Paul, I hear you, but I think it's easy to defend that number, you know?
Yeah, no, I hear what's being said.
You know, 257 is an odd number. How about 260?
Well, that's what that was gonna be my recommendation. Let's pick a round number, and it's got a little bit of,
Why go up? Go down.
wiggle.
If you're gonna round, you can round down as well as up.
260, somebody builds a three-room hotel.
255.
I'll see
Well,
you at
yeah,
255.
I mean, it's neither here nor there, you know?
Yeah, right, it's neither here nor there, right. 257.
I
It's
think
it's based on some reasoning.
it is, that's
Yeah,
the point. It's based on
257.
reasoning.
There you go.
May not be great reasoning, but it's reasoning.
So,
Yeah, it's reasoning, 257.
so
we
I
leave
would
it-
like to, I can work with Ron to revise this paragraph, just to change the language of that.
Clean it up
I
a
don't know
little.
I don't know if you were planning on voting on this tonight.
Yeah, I would like to. I mean,
Subject to edits.
Just subject to any final edits
at the,
that don't change the substance of what is here.
yes, at the bottom of Ron's memo, it says, once the board has had a chance to review the latest draft documents, which we have done, it should consider forwarding the documents to the town council for consideration. The only comment I had was on this number, and I'm happy to go with 257 based on a reasoned approach to that number. If there are any other comments, let's hear them now, and if everyone is okay, we can forward this to the town council.
No, I think we should move this along.
Yeah, I do too. Any other comments? John, other comments? So, Peter, you'll work with Ron on appropriate wording,
Yes, sir.
and then we will move this forward to the town council.
Yes, sir.
Very good. Do we need to vote on that?
I think you should. I think you should
We have a motion
vote on the
to
current
As
draft.
stated by the solicitor and the chair.
have the solicitor work with the planner, the town planner, to revise any wording as is deemed necessary, and then forward this to the town council for approval.
I'll make that motion.
I'll second it.
Motion's made and seconded. Any further discussion? All those in favor say aye.
Aye.
Opposed, nay. Motion passes. Thank you. Next item is item 6, updates. 6A is a status report. Any comments on the status report? I had a question for Ron, but since he's not here, I'll just postpone the question. I assume there's no further word on the BRAC status?
Actually, so I did receive a message from our attorney. It appears we're on schedule for a FOST on the Green Lane property for June of 2021. That's the schedule right now.
Wow, good. Thank you, Sean.
And then just the RFP or RFI for the Navy Lodge through JFK Properties
Yeah,
has
right.
been, I believe, sent out by the finance office.
Yep, yep. We all saw that. That was a very nice package, by the way. Committee reports, Rural Village,
Sleeping.
sleeping, yeah. Use table?
Not sleeping. We have another meeting scheduled. I don't know when, but we've been meeting regularly.
18.
Yeah.
18.
Marijuana regulation?
Yes, so things have been put on hold because there were new regulations for the medical marijuana program that DBR had put out. Those were sort of on hiatus, given some activity going on at the General Assembly. Checked with DBR. Those are now moving forward. We've got to check to see whether they've made any further revisions to the regulations. But I've been advised that those are final and they will be effective as of March 25th. And they've said they're guaranteed that those will go into effect, so now we can continue the process of revising the draft of the proposed regulations.
So do you need to do some work on the draft before?
Dwight, Mary and I need to do some further work now that the DBR regulations have been finalized, so we can make sure that the initial draft we did, which was based on the old regulations, will be compliant with the new ones.
Okay, so once your revisions are completed, then you'll notify Ron?
We'll notify Ron and
John.
schedule another subcommittee meeting with John and the subcommittee.
Okay, very good. Airport zoning, we have dealt with already this evening. Tree Commission?
Nothing new except Earth Day, which is coming up, and I imagine that a number of meetings might be canceled and activities. That's the 18th of April.
Thank you. Open Space and Fields?
Okay, so at the last meeting, they again discussed the pickleball search for a location for a site, in Middletown. I guess the group looked at, someplace over by, I guess, Corday Field, where one of the baseball fields is, and determined that wasn't appropriate. And then, so their recommendation to go back to the town council was to say that the Linden School site was the best location for a proposed pickleball court site. They're also discussing Earth Day planning, and they're discussing open space scoring of certain plots of land in the town. That's it.
Thank you. Joe, do you have anything further on the Conservation Commission?
No, other than we have a new officers on the Conservation Commission, new chairman and vice chair and secretary.
Who's the chair?
I'm gonna have to find Jim Gedney, I believe.
Jim
Doc Gedney.
And that, we reviewed the Campos application Monday night, and, we're gonna have a full complement of people going forward now, I think, on a pretty consistent basis.
Oh, that's good. That's good. AI?
Back up, who's the chair of the open space? Is that still Hawes?
Cougar.
Oh, Bill,
Nicholas?
Nick, oh, really? Is Hawes still on it? Mason Hawes?
I haven't seen him at the last few meetings, but,
Take that
he's
up
still
after.
a member.
Let's keep this meeting going. Quidnick Island Planning Commission.
All right, the executive director has left and gone to Maine for a new position, and the existing staff is going to stumble along. I don't mean to make light of it, but the Island Waters Plan, which is funded, is going to continue, and that's one of the first projects is going to be dealing with the retention basins and where John and I live at. And there's been some talk about maybe putting together a combination of the Quidnick Island Planning Commission and a adjunct of the Chamber of Commerce. But that's still in the planning phase, and they want to come around, this part of the staff, and talk to each town manager. And I suggested to them that if they're going to talk to the town manager, it would be wise to have the president of the council and the planner there. So we'll see where that goes. But they just want to kind of bring everybody up to date. And it's the same problem they've had in the 20 years I've been associated with them. They don't have a consistent funding line. It's all based on, from like the local people here that have money and so on. And the suggestion has been made by me and several other people, there should be a funding line by the state, but nobody's been able to accomplish that.
Okay, thank you, Art. I know we have subcommittee meetings scheduled, the dates aren't shown, but our next regular meeting is April 8th. Anything else to come before the board this evening? We have a motion to adjourn.
So moved.
Second.
Motion made and seconded to adjourn. All those in favor say aye.
Aye.
Motion, the meeting is adjourned. Thank you all.